Hi, good morning, everyone. Welcome to our webinar. Welcome to Derek from Collection House, who are long-term partners of the LGFP. Derek's going to be talking about sale of land for overdue rates process today. It's a topic that's, quite controversial in some councils. We'll be happy at the end of the session. There's a Q&A box on the right-hand side of your screen. If you have any questions, just enter them and we'll answer them at the end. If we run out of time, we'll get some answers to you posted on our members website. Welcome, Derek, and I'll hand over to you.
Good morning all, and thank you for the introduction, Zoe. My name is Derek Cashin, an associate here with CLH Lawyers. Hopefully you all know CLH Lawyers as a subsidiary of Collection House Group, represented on the front line by Sam Camalingo, Lindy Pearson, and Marie Bramadat, who all work tirelessly assisting local governments in Queensland. Unfortunately, Sam and Sheree Angove, Special Counsel with CLH Lawyers, are not able to join me today, and they send their apologies. Firstly, in the spirit of reconciliation, Collection House Limited and CLH Lawyers acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community. I'm speaking to you today from the lands of the Turrbal and Yagara peoples. We pay our respect to their elders, past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples that may be watching today. We thought that a presentation on today's topic might help local governments in the space of selling land for attached overdue rates, whether they be experienced in the process and are looking to tidy up their own procedure either internally or with legal assistance, or whether the council just wishes to get started. LGFP have been good enough to grant us this time and audience, so thank you for coming along. We'll start with the basic process of a council selling land to recover overdue rates and what we think are best practice methods of meeting a local government's obligations. This will include some pointers on what properties qualify for the process, how to get started and then follow through, important timeframes, and what a council can expect throughout the legislative process. Then we'll discuss some things to keep in mind when a council is thinking about whether it is a good idea to submit a property and specific owners to the process. Just because the property has attracted a large debt doesn't necessarily mean it's a good idea to throw it in the mix. We'll also speak about the conveyancing process and what happens after auction, including briefly the sales notice process. Then the second part of the presentation, the potential pitfalls and problems council could encounter. We'll briefly touch on land that might be considered out of the ordinary or difficult to progress on, and different stakeholders which might steer the process in a different way for that particular property. We'll then finish up with a few of our own experiences and experiences of our clients with sensitive issues and how best to carefully approach them. When dealing with those problems and issues, however, nothing beats tailored legal advice if counsel isn't sure, but they can make for interesting anecdotes. So the process is provided for in the local government regulations, at regulations 136 to 151. The sections were amended to update the process in 2020. The old provisions were awkward and forced council into steps such as only being able to negotiate with the highest bidder at an auction, or having to acquire property after an auction where the property was passed in. We think it's great that those provisions are gone. That being said, the regulations are due to expire on the 1st of September of 2023. No doubt there will be a replacement bill brought in by Parliament in the near future. There are three main criteria a property must meet to be sold by council. Firstly, it must have overdue rates and/or charges attached to it. Those can be either rates or charges not paid by their due dates, court-ordered legal costs, expenses in a previous attempt to sell land, or interest. They become overdue the day after their due date. Secondly, the overdue rates and charges must have been overdue for 3 years. An exception to this is if the property is a commercial purposes property only, and a court judgment has been obtained for the debt. The only other exception is if the rates or charges were levied on a mining claim, such as a mining lease permit. Thirdly, there must not be active court proceedings disputing the liability for the rates and charges. This means any court proceedings which has not yet either been discontinued or had judgment or a final order entered by the court. We often see situations where a local government may have started court proceedings with a claim filed in the magistrate's court for overdue rates. From there, they are not able to serve the claim, or they encounter a defence, and then unfortunately let the proceedings go stale. Legal advice should be sought on how to best bring these proceedings to an end in a way which doesn't compromise council's model litigant status. We'll try to speed through the process here, which begins with a resolution passed at a local council meeting to decide to sell the land under Regulation 140. The resolution must stipulate wording that council is deciding to sell the land or a number of properties under that regulation. For practical purposes, we always recommend that council provide in that resolution delegated powers for the chief executive officer and or another employed representative of council with day-to-day dealings and accessibility, the ability to negotiate and or stop the process should it be deemed a good idea to do so. Without that delegation, the only way to stop the process would be to have councillors meet again to resolve to cease the process, a bit of a burdensome option. The portion of the meeting of the local government deciding to sell the land may take place under closed conditions if the council considers that the disclosure of property identifiers could directly affect the health and safety of an individual. Sale of land procedures are not technically legal proceedings, and so the criteria under Regulation 254J subreg 3E does not apply. Council does not have to close the meeting off to the public, but we think it can choose to do so under subregulation F. It could also identify properties by a lesser known method, such as an assessment number. We're not aware of a hard and fast requirement that properties must be identified in the resolution with addresses or lots and plan numbers. This process is up to the discretion of council to decide a best way forward. From there, council should then obtain title searches for each of the properties and arrange to give a notice of intention to sell to all interested parties. The notice is a document recounting the resolution wording, the sections of the regulations relied on, and a description of the property, the debt and its age, signed by the Chief Executive Officer. Interested parties mean the owners, obviously, but also third parties with registered interests. Generally speaking, the title search gives all the information you need for this step. We often receive questions about what is the best way to send these notices. To strike a balance between covering council, ensuring the process can progress, and being fair to ratepayers and interested parties, we take the approach of sending these notices by ordinary post, as well as to an email address if specified by the common third parties, like banks. The word give has a special meaning provided for in the Acts Interpretation Act, where if legislation requires a document be served on a person, unless contradicted by another act, it may be sent by post to the address of the place of residence or business of the person last known to the person serving the document. There is no specific requirement in the regulations or the Local Government Act that go beyond this. Section 39A specifically says that the sender may rely on the act of sending, and that service is taken to have been effected at the time at which the letter would be delivered in the ordinary course of post, unless the contrary is proved. For that reason, we think the section is complied with by using ordinary post. The last thing you want is to send a document by express post, which can be tracked, or registered post, and have the document either provably rejected or know that it would never turn up at the address. We all know ratepayers who like to either reject or not sign for mail. In a case like this, not knowing for sure the document was never received is better than knowing it wasn't. If a document is ordinarily posted, the sender can rely on the act of sending as giving the document. Different rules apply when the third party is a company or of a special nature, and legal advice should be sought if counsel isn't sure. We also receive questions regarding substituted service. The provisions regarding substituted service in Section 239 of the Local Government Act are an option rather than a requirement. Council may serve the document by publishing a notice that contains a summary of the document in a newspaper circulating generally throughout Queensland and the Gazette, and on their local government website. The notice can be summarised with private information left out, but it must be addressed to the intended recipient by their name. Substituted service of a notice for sale of land procedures would be required in circumstances only where council does not know or is uncertain about the person's current address. It doesn't apply where council knows the owner's address because it's been given to them by the owner or the government department overseeing the titles office at the time. The uncertainty would only be created by having mail returned, and council is ensure that it's just the intended recipient who is rejecting the mail to be difficult. Advertisements in local papers are expensive, so the option should be regarded as a last resort. Once the notice is sent or given, council waits 3 months. If the debt is paid, council must stop. The debt includes all rates and interest and expenses in following the procedure. If it is not paid, in the 3-month window between the notice expiry and the 6 months after it was issued, council must prepare and issue an auction notice, listing the property for auction at least 14 days, but not more than 35 days, before an auction date council sets. The auction notice is advertised, put up at the front of the property, in council's chambers and on their website, and usually in a local newspaper. This part of the process cannot be skipped, and the property must not be offered for private sale first. A venue is booked, an auctioneer is appointed, contracts are prepared, and the auction is held at which the property must sell for either reserve price or above. If it's passed in, council can approach any bidder during that auction to negotiate a sale above reserve. After that, the conveyancing process begins, where transfer forms are prepared pursuant to a contract with the buyer. The buyer has most of the responsibility of preparing those and doing the settlement adjustments. When the sale occurs, almost all registered encumbrances on freehold land are wiped from the title, and funds are distributed in a set priority from settlement proceeds. We usually recommend council takes those funds into trust and attends to the distribution afterwards. Usually, a mortgagee stands to lose when council sells property. They lose their registered mortgage and may only get part or none of their loan debt back from the sale proceeds. The prudent banks, we find, will agree to either pay the debt themselves and tack it on to the mortgage loan debt, or strongly encourage the ratepayer to pay the debt to avoid the council sale. Not paying your council rates is a breach of your mortgage contract. So if the matter gets this far, the bank will usually breach the ratepayer on their mortgage, pay the debt, and then take possession of the property to sell themselves. This way they give themselves the best chance of being paid their entire debt. This all happening in the background helps council because it adds more pressure to the ratepayer to do something about this serious action council is taking. Of course, if Collection House is conducting the land sale for council, its staff attend to all these negotiations with the ratepayer and the mortgagee or other interested parties. If the auction fails and negotiations with bidders fall through, council has options in that it might follow the same procedure again to sell at a second auction, or it could issue a sales notice inviting private offers to purchase the property. A final option is to acquire the property itself at the price of the rates and charges debt by waiving it. Most commonly, we find our clients wish to proceed with the sales notice procedure after an auction that doesn't obtain enough interest. Not every property is desirable enough to warrant bidder attention. The sales notice procedure starts if council ends all negotiations with auction bidders. Like an auction notice, a sales notice is prepared and given to all interested parties, advertised at council's offices, and appointed at the front of the property. The property must be sold at higher than reserve, which we do a deep dive into a little later. Generally, we think council can use the unimproved rateable value of the land, but this should be looked at on a case-by-case basis. If council sets too high a reserve, it risks not being able to sell. Finally, the whole process must stop 12 months after issuing the original notice of intention to sell. We take this to mean that the legislative process needs to stop, including all steps taken up to the entering into a private contract with a buyer. We think that a contract settlement period can go over the 12-month time limit, because at that point it is a binding private contract between parties which needs to be followed through with, and is no longer a relationship governed by the regulations, practically speaking. For example, if you issue a notice of intention to sell on the 1st of July of 2022 and enter into a contract of sale after a sales notice on the 23rd of June of 2023, due to settle on the 23rd of July of 2023, we think that would be fine. Thankfully, and as a creature of statute, local governments have a few options when deciding how to recover rates. After all, they need the money to operate for the benefit of all ratepayers. Accordingly, council needs to decide whether to start court proceedings or wait for the property to meet sale of land qualifications instead. Again, we all know those ratepayers who like to dig up ridiculous legal defences on the internet and slap them into a defence court document opposing a claim for unpaid rates. As silly as they are, a defence can delay judgment and finalisation of court proceedings, which, whilst active, as we said before, would prevent sale of land action. Having said that, if council thinks a legitimate dispute might exist, it could be a good idea to seek a court's ruling before taking the quite drastic step of selling land out from under a ratepayer. We think that a good rule of thumb is that if the property is relatively common in most characteristics with no outstanding circumstances or sensitive issues, and the debt is over 3 years old, council should probably submit it to sale of land procedures rather than give the owner a chance to delay recovery in court. Of course, it's always a good idea to seek legal advice if unsure. Speaking of rules of thumbs, council should never let a property sit in a too hard basket and needs to proactively manage the age of its debt. In our opinion, the law is unsettled with just how long a rates debt can be owing before it becomes unrecoverable. And if it is unrecoverable, by what means is it unrecoverable? The Limitation of Actions Act provides that action against a person for recovery of debts has a 6-year time limit. This includes council rates. It also provides that action against property can have a 12-year time limit. The famous Brisbane City Council and Amos case indicates that action for recovery of rates may not clearly be one way or the other, even though logic would tell us that sale of land procedures are an action against property only, rather than suing a ratepayer personally in court. For that reason, we think it's best practice to wait for debts to pass a 3-year age, but not let them approach 5 or more years to avoid a challenge against being paid any portion of it due to limitations legislation. So, what happens after auction? Ideally, council will have engaged a conveyancer or a legal representation to draw up a contract of sale suitable for a sale of this nature. Of course, and because the local government doesn't own the property, it can't grant access to the building for building and pest inspections or warrant it to be in any sort of condition, or even that it'll be empty of persons and chattels. The standard REIQ contracts by themselves are therefore inappropriate. There are a number of different ways to deal with the REIQ limitations, including a separate contract drawn specially for the occasion. We take the approach of tailoring special conditions which amend, exclude, or add to the REIQ template, and annex the special conditions to that template. We think this best ensures council can keep up with changing community expectations, such as the recently added ability to once extend the settlement date for a party, brought in earlier this year because of COVID-related bank delays with approving home loans. We think that still using the REIQ contracts to include clauses like this, but having special conditions annexed to it, is the best approach to avoid any bad publicity for council in circumstances where, say, someone is prevented for reasons outside of their control to not be able to attend settlement, such as COVID or external party delay. The last thing a local government wants is negative media attention around a settlement or sale. It just might discourage buyers for future auctions. During the contract settlement period, the buyers prepare transfer forms acceptable to the titles registry, and the Chief Executive Officer of Council signs in most cases. They can also be signed by the Mayor or a representative with delegated authority. If the property is part of a body corporate, Council has to take reasonable steps to comply with the Body Corporate and Community Management Act by contacting the body corporate to obtain an information certificate and disclosure statement. These documents, if they can be obtained, detail the financial affairs of the body corporate and any debts owing to the body corporate by the old owner. Sometimes bodies corporate are run by the recalcitrant ratepayer themselves or are unrepresented by a management company, so getting a response can be quite difficult. Regardless, those debts do attach to the property, so the new owner would become responsible for them if they're not paid from settlement. As settlement approaches, a schedule of settlement adjustments is drawn up by the buyer and agreed to by the parties. Due to limitations with PEXA and other online settlement facilities, a physical settlement is still required, and we think it best practice to require the buyers to deliver bank checks to Council's offices. Funds are received by Council in an order which pays the amounts owing to the state, expenses of the sale, land tax, overdue rates and charges, other amounts owing to the local government, current rates and charges, registered third-party interests such as the mortgagee loan, then the body corporate, and finally, the leftover is paid to the former owner. This final destination of funds can change depending on the nature of the former owner, and we'll discuss that a little bit later. If any funds remain unclaimed after 2 years, Council pays them to the Office of the Public Trustee as unclaimed monies. We have to be clear. What Council does under the regulation is sell title to the property to the buyer and is permitted to transfer title to the buyer free of encumbrances and nothing more. Council does nothing to warrant the property is in a certain state, complies with any legislation like fencing or smoke alarm legislation, nor does it sell any removable chattels found on the property to the new owner. It only passes clear title. Registered interests other than state interests or easements are removed from the title. The buyer is then entitled to take steps as the owner of the property to obtain possession. Those steps depend on the attitude of the former owner and occupants. If they make life difficult for the buyer may need to apply to the court for orders directing the occupants to vacate. If if they do not leave then, the buyer could obtain a warrant enforceable by court officers and local police to evict the persons who refuse to leave. But that is not Council's concern, and Council should never give advice to this effect either. As with all curly questions, the best approach is to recommend an interested buyer seek their own advice as to how to best possess the property lawfully. Now, we move on to the problem part of the presentation, specifically regarding what local governments should do when they find a property or a stakeholder are a little out of the ordinary or difficult. Collection House has been doing this work in earnest now for more than 10 years, and has had the opportunity to work with a number of you and your councils in getting the process underway. We've been able to pick up a little bit of experience with these types of difficult situations, and we're going to run through some of those examples now. No doubt about it, you would have all encountered hostile ratepayers in your lines of work. Those who think they're sovereign citizens of the Queen or King, and that local governments are unconstitutional, or that they themselves are not living persons, or some other nonsense. That could be a whole different webinar. Our recommendation in dealing with those statements is in writing is to respond once to let them know we do not agree and that they should seek their own legal advice and leave it at that. If Collection House is conducting your land sale for you, we would ask Council not to respond and bring them to Sam Cummerlingo's attention. A lawyer will respond for Council. From there, those types of ratepayers are going to struggle to meaningfully oppose sale of land action with those arguments. But there are the rare few who take matters a step further and into their own hands. Dangerously, we have encountered threats against our physical persons, or even worse, against council employees who have to live and work in the region. Some ratepayers will receive a notice of intention to sell and then turn up at council's offices with threats of recording conversations and physical harm. Others will be silent the whole way through the process and then turn up at the auction to cause problems. Sometimes it is appropriate for council to approach the local police department and ask for an officer to be present at auction to protect proceedings and everyone else. We find most police departments to be accommodating if a genuine threat can be pointed to. At worst, a venue with security could be hired for the auction itself, such as a licensed venue. Again, in those scenarios, we continuously refer those people to seek their own legal advice and inform them that they need to leave if they do not wish to engage appropriately. However, council should keep in mind that these types of ratepayers do exist, and if a ratepayer is known to council for perhaps having a violent history or attitude, extreme caution should be taken in dealing with them and the property. Unfortunately, and one time, we attended an auction for a council which gathered local media attention. A reporter attended and remained outside the venue. Once an auction had concluded, the reporter approached a successful bidder, who was a relatively young person with a young child present, and interviewed them for the local paper. Unfortunately, the buyer proceeded to allow a picture to be taken of themselves and identified themselves. The current registered owners at the time obtained the article, found who had bought their property, and proceeded to harass the buyer. All manner of disgusting threats were made, and understandably, the buyer found themselves in a pretty horrible situation. I have to be clear that this was not the local council's doing, but it certainly did put the council in a situation where a tough decision had to be made. On the day of the auction, we always recommend to bidders and buyers that they do not speak to the media, and they be very careful with their own identities. Of course, you can't stop people from doing things, but it's just a good idea to try to bring buyers down to earth a little as they sign the contract. Sometimes it's a whirlwind experience, and buyers can be a little too excited afterwards. If an owner is bankrupt, that may or may not show on the title search. For our purposes, it doesn't matter. The Bankruptcy Act provides that when a person is bankrupted, the property they owned at the time vests in their trustee. This means that any interest the property had in the property being sold is now the property of the trustee. The trustee is entitled to receive the funds of the funds the bankrupt otherwise might have, and then use those monies to pay creditors of the bankrupt estate. Sometimes the trustee will register their name on title. Sometimes they will not. If council becomes aware at any stage the owner is a bankrupt, their trustee should be contacted. The two exceptions to this are if the trustee has disclaimed the property because they deem it not worth realising as the debts outweigh the value of it, or if the bankrupt owned the property as trustee under a trust, like a family trust. Their name will appear on Queensland title searches as trustee under an instrument number. If they do, then the funds will be payable to the bankrupt, in most cases to retain as property of their trust. When the property vests in a trustee, they may decide to register the name on title by way of transmission. When a trustee decides to register transmission of that interest and appear on title as the trustee of the bankrupt estate of the owner, this doesn't prevent sale of land action. It's entirely possible the bankruptcy administration will not have funds to pay the debt to stop it. Instead, the bankruptcy trustee may attempt to sell the property first and before council. Council's actions will just put a rocket in their plans and force them to hurry up with that. In the end, it doesn't really matter to council who sells the property. They'll be paid either way. As a side note, we would caution any council looking to sue a trustee of a bankrupt estate for unpaid rates, even if they appear as the registered owner. The trustee of a bankrupt estate is not personally liable for debts owed by the bankrupt estate, And so the law is unsettled on how to actually go about starting court proceedings against them. You cannot sue the trustee, and you cannot sue the bankrupt estate. But that speaks to a topic for another time. Right at the beginning of the process, and if council finds that the owner is an Australian company, an ASIC search should be conducted to identify both whether the company is still registered and what their registered office is. All notices of intention to sell and auction notices should be sent by ordinary post to that registered office in the case of a company owner. If the search identifies the company is deregistered, the property has vested in ASIC as the federal government's representative under the Corporations Act. All notices should be given to ASIC's property law group, which will usually be quite helpful in assisting with who council should contact and where funds should go once the process is said and done. It's not uncommon to see that a company owns property as trustee under an instrument number, and if that company is deregistered, we think it's unclear at law as to who the proceeds of settlement might vest in. It could be ASIC, it could be the state government. This is another reason why it's a good idea to correspond with ASIC as soon as possible, putting to them that they should convince council that they should receive the funds. For the most part, we don't really care who fights over the leftover money. If a party wants it enough, they'll go to the effort of seeking court direction as to its payment. Council's fine to hold it in trust until then. There are a number of different reserve pricing strategies a council can take, and in our view, the law is unsettled. When I say unsettled, I mean we do not think the interpretation of the statute has been challenged yet in court. Regulation 143 states that the local government has to sell the property for a reserve price that is at least A, the market value of the land, or B, the higher of either the amount of overdue rates or charges or the value of the land. Now, market value, as a defined term, dictates that a written report by a registered valuer is evidence of market value, but the regulations do not actually exclude other forms of evidence of market value. It's obviously very difficult to arrange a registered valuation over property you cannot grant access to. But I understand some valuers will do a curbside type appraisal and report without having access. In our view, it's best to rely on the second option, that being that the reserve price is set on either the debt quantum or the value of the land, distinct from market value. With value of the land being defined under Regulation 72 as having regard to the Land Valuation Act, we take it to mean that the value of the land itself given by the valuer general, i.e. the rateable value of the land. Having a lower reserve gives council the best chance of office meeting it, and the property being sold, which in the end is the goal for council. This strategy might need altering if council is aware of large attached debts, and a larger reserve price might be required to ensure those debts are somewhat catered for. A property with very old rate debts can sometimes be a very undesirable property. It could be because of unfortunate circumstances, like a fire or contamination issue. It could be abandoned by the former owner. In one scenario we faced, the former owner lived in what was apparently a demountable house on the property. A week out from the auction, the property was worth a not small amount given the house. Unfortunately, and the day before the auction, the former owner up and left with the demountable house, significantly reducing the property value. That was a rude fright for the successful buyer. Still further, you can encounter a unit in a body corporate which hasn't had its body corporate levies paid for a long number of years. Because those debts, land tax and other debts attached to the land, the new buyer becomes responsible to pay those debts if they're not satisfied in full by the purchase price monies. Say you purchase a unit for $40,000 at a council auction. That unit might have $25,000 in unpaid body corporate levies, interest charged at 30% per annum, and the legal costs if it was subject to recovery action by the body corporate. It might also be stuck with land tax and, say, $20,000 in council rates as a hypothetical. If it was purchased for $40,000, the new owner might be stuck with having to outlay even more money to clear the attached debts. This would be one of the circumstances where a strategy around reserve pricing should be considered. Another attached debt could be a state encumbrance, such as child support charges. These debts are paid quite high in the priority listing, so a council should be proactive in finding out just what is owed. This could also factor into reserve pricing strategy. A reserve price should be set at a sufficient amount to pay both these charges and council's debt. In the case of a leasehold property, which are admittedly rare to find these days, a title search will clearly identify it. When council sells the property, they are selling the leasehold interest only and must urgently seek consent from the state government to do so. Consent is not usually withheld, but rent arrears need to be paid to the state government before settlement. Again, another issue to consider in setting a reserve price. For all of these situations, and I must sound like a broken record by now, tailored legal advice helps. We've also come across difficult situations where there are multiple lots rated together, and their reserve pricing was excessively high. These lots can have access to a road and are standalone, but are in a combined assessment for either convenience or because the owner is the same entity. A reserve price could be set on the combined value of the land with the value of each lot added together. But in the end, this might result in a very high reserve price and limit council's opportunity to sell. We think in that scenario that council is entitled to seek a de-amalgamation of the properties with cooperation from the Land Valuer General, and having each lot sold separately with a proportionate amount of the attached rates debt attributed to that lot. Unless such an approach would cause practical problems such as no access to a road or connection issues, we think that this is a practical way to see the land dealt with. Most councils will be well versed in the fact that if a land is held by an Aboriginal land trust, the land is not rateable land. This type of ownership can be identified from a title search, which will have specific wording like the wording you can see here on the slide. Whilst rates do not generally accrue when the land is undeveloped, utility charges can accrue on that property. If the utility charges are significant and aged, council may be considering whether or not that land can be added to sale of land procedures to recover those utility debts. Well, I'm here to tell you that it's our view this cannot be done, and any attempt to register a transfer would be void. The structure of ownership is governed by the Aboriginal Land Act and the deed of grant registered on title. The only way the land can be transferred is by the state government Minister for Resources or by application made by the Aboriginal Trust to convert the land to freehold. We anticipate the way this land is protected is to safely afford considerable protection to Aboriginal and Torres Strait Islander land and to avoid any situation where land with significant cultural heritage is removed from the possession of those traditional custodian communities. We are not aware of any attempt by any council to try to take the step of selling such land. Whilst it is a little off track, in a situation where council is owed money by an Aboriginal land trust, considered legal advice should be sought, but council may have the option of reducing water supply to encourage repayment of utility charges, or to sue the Aboriginal Land Trust in its body corporate capacity personally. If that option was taken, enforcement could not take place over the land. As a statutory and government body, council has an underlying obligation to act as a model litigant in everything it does in the space of both compliance with law and in court proceedings or legal action against other parties. That's not new information to most of you. We have, though, provided advice to councils in the past around what might be considered sharp practice and how to best approach a situation where strict compliance with the law may not necessarily be ethical or upholding of model litigant status. In the space of sale of land, if council finds itself a party to court proceedings, disputing liability for rates and the proceedings are defended, Technically speaking, discontinuing those proceedings would allow sale of land action. Discontinuing in a defendant's civil case requires both parties' consent, so counsel may be tempted to encourage a defendant to agree to discontinue, only to turn around and subject them to sale of land proceedings. Hopefully, we do not need to be too convincing in saying that this idea is a bad one. If a proceeding is disputed, counsel should see it through. We would never recommend inducing a defendant owner to discontinue proceedings in good faith before immediately starting sale of land procedures. We think this would undoubtedly constitute sharp practice. You might remember my saying that we recommend when counsel starts sale of land proceedings to also resolve that the Chief Executive Officer or an employee with accessibility be given delegated authority to make decisions on a case-by-case basis. It is because of situations around hardship and legal capacity that we make that recommendation. Again, the last thing council wants is bad publicity around a ratepayer's inability to pay. If council becomes concerned the owner may lack capacity to deal with the matter, or if otherwise a more palatable settlement can be reached, including the release of superannuation funds or otherwise, then council will want the ability and power to conveniently cease action on that type of matter. Obviously, this is a case-by-case basis consideration, and if council has any questions on a matter like this, legal advice should be sought. The final slide. We made it. Some quick takeaways. Sale of land is specially tailored to allow council to move on with their business and recover the rates and charges they're owed without protracted court proceedings. It's a good idea in most cases and should be taken advantage of. If council is concerned about the perception of incurring expenses in seeking assistance to make sure of the process and its compliance, we say council should not be worried. All costs are recoverable, and in the grand scheme of things, most expenses are quite reasonable. Employees should be quick to move on any extraordinary incidents or issues with a property and give careful consideration to which properties council wishes to proceed with. Human nature sometimes means ratepayers wait until the week before the auction to raise a legitimate issue, and council should be prepared to pull a property from auction if there's an extraordinary issue around hardship or capacity which might warrant that being a good idea. We almost always recommend reserve prices are the unimproved value of land. Council can take the extra step of seeking a registered valuer's comment or report, and those costs are recoverable from the sale funds. However, until a matter proceeds through the courts to challenge a reserve price, we think council does not need to go to that length. As always, ensure you are highly organised and planning for the worst. If a hint of a threat is received that a ratepayer may cause trouble, either at council's offices or at the auction, then an appropriate response should be planned for involving police or security. One thing we like to do when we sit the successful bidder down to execute the contract is to let them know quietly of any media presence and suggest to them that they do not undertake any interview or make their identity known to anyone. Again, you can't stop people from doing things like plastering the fact they bought a house all over Facebook, but it's probably a good idea to quietly convey this suggestion to hopefully avoid a horrible situation. Last, but certainly not least, do not have a too hard basket. Both professionally and in sale of land considerations, it's a bad idea. Don't let problems snowball. Seek advice if the matter is complex. And that brings to an end to what I have to say. I'm happy to take any questions. If they're detailed questions or if I do not know the answer off the top of my head, I'd be happy to take the question and respond at a later date once we've investigated a right answer. Sam Camalingo is the best point of contact for Collection House Group, and her email is on the final slide. Thank you.
Wow, that was a really informative presentation, Derek. Thank you. We do have quite a few questions. Now, we've got about 15 minutes left on the webinar, so if you have any questions, please pop them into the live Q&A. Now's an opportunity, and hopefully we can get them answered for you. So there's quite a few, Derek. The first one was, how was the reserve price set? I'm hoping that we've answered that through the presentation and through the wrap up just then. But the person who put that in, if you still have further questions about that, feel free to put some more detailed question in the Q&A and we can circle back. So what have we got here? So substituted service. If the last known address was in another state, should we be advertising in a newspaper that circulates in that state as well as Queensland?
Good question. If the address is in another state and council knows that the owner is still at that address, I would say to send the notice to that address. Substituted service doesn't need to be done in that case. The only case substitute service might be enlivened then is if mail is being returned from that out-of-state address. If that was occurring, then I think the matter would need to be considered carefully on a case-by-case basis about how to go about it. If they have an agent in Queensland, the notice could be given to them instead. But the section does dictate that the substituted service of a notice summary would only have to be given in a newspaper circulating in Queensland only. It doesn't say that it needs to be in a newspaper circulating in that other state. And so, without having considered the matter specially, I think it would only need to be circulated in a Queensland newspaper.
Okay. So, Derek, you talked about delivering the notice via ordinary mail. If you're getting returned mail from an address for many, many years, but you've maybe had interaction with a ratepayer via email, but they won't give you an updated address, how do you go about that one if you've got an email but you can't get a physical address for them?
All right, so Section 239 of the Local Government Act would again need to be looked at carefully on a case-by-case basis. If the address is having returned mail, but you're certain it's just the owner rejecting mail because they're writing nonsense on their returned envelopes or what have you, then we say that the notice sending can be relied on as having given that notice. If it's being returned and you're informed that the person is no longer at that address, then yes, the substituted service provisions would have to be enlivened. A summary of that notice would need to be advertised in a local newspaper, or a newspaper circulating throughout Queensland, so such as the Courier Mail, which I think is Queensland wide, and in the Government Gazette, and on the local government's website. Beyond that, council can't do much more and can rely on those acts, I think, as having given the notice.
Okay. Thanks very much for that one. We've got a couple here about proceeds. So, Derek, you recommended that the settlement funds be paid by bank cheque delivered to the council offices. What if the buyer is not in the same location and there's no banks in the region, for example, remote and rural councils? What's your recommendation then?
We would say council should take the checks, and we generally require 2 checks, one payable to council to satisfy its debt, and 2 payable to council which it takes into trust. From those trust proceeds, council has 2 years to investigate a way to get the funds to the buyer if they are the destination. If they're not the destination, council can contact the bank, other parties that are entitled to the funds beforehand, but they have 2 years to deal with the funds from the trust account. And so the check should be cashed to council's trust account and then held there until council is sure it can comply with distributing the funds from its trust account to the right parties. I hope that
What if
answers the
there,
question.
what if there's most properties have like BPay or something, and sometimes on ordinary settlements now we have solicitors who aren't using PEXA BPay, for example. What if the buyer's solicitor wants to, instead of the bank checks, what if they want to go through BPay?
We would require a physical settlement anyway, just to avoid any electronic delay or problems with payments being made electronically. I know that we're in a brand new world, and electronic settlements are the rage, certainly for other conveyances, not these types of conveyances. But I think we would still require a physical check presented to council to avoid any problems with the funds making it there on the day. That's probably a preference thing, and I'm sure arrangements can be made with the buyer's solicitor to ensure that funds are paid on time. I think we have done that before, where funds are paid from the solicitor's trust account, the buyer's solicitor's trust account, to council's trust account, and they provide a receipt for proof of that payment. And I think we've taken that as satisfactory in circumstances where I think the property was in North Queensland and the solicitors were on the Gold Coast. And so that was the best way to facilitate it. So it can be done, certainly. But I think for council's convenience, we usually request that physical checks are presented at the office.
Okay. The next one around proceeds and the settlement is if a bankruptcy trustee has disclaimed a property, and particularly if it's an individual bankrupt, who do the remaining proceeds go to? Do they go to the bankrupt?
Good question. The funds vest in the official trustee's office, so the office of the public trustee. They should be contacted as soon as possible to ask them what they would like done with the funds. They might be aware that the trustee has attempted to reclaim the property, which can be done, or there might be other things going on in the background. I think council is best served by contacting the office of the public trustee and putting it to them that they should convince council that they should receive the funds. They probably are entitled to them, but council doesn't need to pay the funds to them without being convinced that they should. So that's the approach I would take and recommend council would take.
Okay. We've got a few more questions, and again, we've probably got some time if anyone has any more questions to pop them in the Q&A. These ones are around the recoverable cost of when you're going to sell a property.
Yes.
So you talked about the potential security or police presence at an auction, a recoverable cost of sale.
I think it's arguably yes. Certainly that has not been tested through the court system to my knowledge, but the expenses of sale being the terminology used in the provision, we would take as quite broad in covering many different types of expenses. And I think the cost of security is reasonably, certainly if a threat can be pointed to and the reasonableness of hiring that security can be shown, then the expenses are recoverable. Yes, that would be my opinion.
Okay. Well, this one's around the legal advice. So if council needs to obtain legal advice in relation to an individual property to determine what approach to take to sale,
Yes.
again, is that an expense to do with the sale?
Yes, it certainly is. So I can only speak for how Collection House and CLH lawyers approach a situation like this. We, with our clients, have agreements where fixed prices are charged at certain steps of the process. Those fixed costs include everything involved in that step, and that includes advice. So my opinion is that certainly it is recoverable. It depends on the cost agreement that the council may have with their legal representation. If a matter is litigated, for example, and it becomes defended, and there's an injunction in the Supreme Court to oppose sale of land action, I think in that case it's possibly arguably not recoverable unless the court orders that it is. But in the general circumstance where matters are fairly routine, then my opinion is that yes, it is an expense that council can recover at sale. And again, I think I put in my takeaway that we always recommend legal advice be obtained, and that council should not be worried for getting that advice, council is well and truly entitled to seek legal advice in dealing with its statutory obligations, and it shouldn't be afraid of incurring those expenses because, as I said, in my opinion, they're recoverable.
Okay. So completely different tact now. So
Yes.
is an Aboriginal corporation treated the same as an Aboriginal trust?
No. So an Aboriginal incorporated entity, an Aboriginal incorporation, or I think it's called an Indigenous corporation, um, are different in terms of they are usually the registered owners of freehold land. Freehold land can be subjected to sale of land procedures. Nothing stopping that. The corporation has a registered office. Notices should be sent to that registered office. They are under a different legislation, and I think a different entity looks after the keeping of those records. But nothing prevents the sale of land owned by Aboriginal or Indigenous corporations. An Aboriginal land trust is a completely different entity in itself, governed by a different act, and has cultural protections over property that it's the registered owner of on behalf of ancestors and descendants. It's a completely different kettle of fish, so to say.
Okay. Oh, they're coming in thick and fast now.
Gosh.
Yeah. So for a deceased estate with no will, what would be the best approach to take?
So the passing of an owner, if the owner is still registered on title, it doesn't prevent the action. But my opinion off the top of my head is that notices can be sent to the executor of the deceased estate at the address council has, if council's not aware of any different address. And if they don't have a copy of the will, then they wouldn't be. But I think it would need to be considered on a case by case basis where the executor has contacted council or someone has saying that, hey, the owner has passed away. Um, a request should be made to that person for copies of the will, probate orders, anything else showing how far along the administration of the deceased estate is. So the short answer is it depends. And we'd have to consider that matter specially. Collection House, as part of its value add, I suppose, contacts these parties and asks for this evidence so that council can be sure that they are sending the notice to the right person or place and distributing funds correctly when it's all said and done. But the procedure can progress. It doesn't need to stop.
Okay, the next one is about a deceased estate again, and it looks like it's a very specific circumstance that a council out there might have. So what are your thoughts with a property that is in an individual ratepayer name, which is an estate, and the public trustee have advised that they do not intend to accept the estate for administration? How would we comply with the ability? How do we have the ability to comply with giving a notice of intention to sell to the registered owner? So I'm guessing if we really have no idea who's representing the estate.
Right. I think that matter needs special consideration. I'm sorry I can't
Mm.
give an answer with the limited time we've got left, but off the top of my head, I don't know. We would need more information. Um, I think the public trustee can be contacted. A search of court records can be done to see if any probate orders have been obtained for the person or their estate. It really depends. I think more information is required, and certainly council could put feelers out with the official, the office for the public trustee to ask for their guidance as to what council should do from there. But again, I'm sorry I can't answer that in a nutshell. I'm afraid. I'm happy to take the question
Yeah.
and look into it further, of course, as I said. But yeah, that's a very special circumstance. It sounds like.
Mm. We've got about a minute remaining, but we can go a little bit over time if people want to hang
Oh,
around for a
great.
bit longer.
Okay.
So if a council has an onerous property that has been disclaimed by trustees and legal advice initially suggested the property may now be vested in the ASIC, but they reject this, is the public trustee the owner? Oh, that's a good one. Who owns the property?
If the owner was a person and the person was bankrupted, I assume that's the circumstance in which a trustee has become
I'm thinking
involved.
if it's to do with ASIC, it might this circumstance
Well,
might be a company, maybe.
that's the thing. Perhaps it was
Mm.
disclaimed by liquidators rather than a trustee. And if it was,
Oh.
then yes, the property vests in ASIC. If they reject this, I would like to see a copy of their advice as to why. Maybe the property was owned by the company as registered as trustee of a trust, and maybe there's some dispute there. If it's not vested in ASIC and they give some good reasons as to why not, it may be vested in the state government. So that very rarely happens, and I probably can't get into it too much further without seeing the circumstances of the matter. Again, that's a very rare and special circumstance or question that really needs considered legal advice. I'm sorry, I cannot give a definite answer without knowing everything.
Okay. Oh, this is a long one too. The in Titles Queensland announced that e-conveyancing will be mandated from the 20th of February 2023, following the making of the Land Title Regulation 2022. Unless exempted, it will be mandatory for certain types of instruments and documents to be lodged and deposited through the electronic lodgement network. Will this change how the sale of land is processed?
Really good question. So we would work with PEXA and other online settlement facilities. I think Simply is another one, but we work with PEXA just personally. We would need to work with PEXA as to how that can be done. So currently, the limitation with PEXA is that only the registered owner of the property can sign a transfer. Obviously, council is not the registered owner, and so having council entered as the transferor is not possible right now. If it becomes mandated, then PEXA is going to need to find a way, and Simply, of course, is going to need to find a way to make that possible. I'm not currently in correspondence with them to address that, but I'm sure that that is something that needs to be discussed with them, and they need to address first. In terms of how it would affect what goes on, PEXA will probably make things easier if it can be done in such a way where the owner can be inserted as the local government. Then we welcome that. That sounds great. But again, it's not something we've had to address yet because of the limitations currently in place.
Okay, so we've got our final question.
All right.
If there's three owners and only one owner is contactable, can the notice of intent to sell proceedings continue if the one owner doesn't know where the other two owners are?
Short answer, yes. The procedure can progress. In terms of sending a notice, you do have to send the notice to all interested parties. Now, when the property is transferred into those three owners' names, the Department for Natural Resources or Mines and Energy, or whatever the department was at the time overseeing the Queensland Titles Registry, would have given council some advice as to the address for service of notices for the owners. Now, council will have entered that into its land record, and that land record suffices for sending those notices to each of those owners, unless council has received some evidence otherwise. So if notices are being rejected by those owners or what have you, then a different approach, say substituted service, would need to be considered. But unless those notices are being rejected, I think council can rely on sending the notice to the address given to council, one to each party, to each owner, and rely on sending that notice as having served the notice. If council isn't sure of where the parties are, or maybe the one owner is just telling porkies, then I think the matter needs to be carefully considered further. And I can't give a definite answer beyond that, unfortunately. Legal advice should be sought.
I feel like you've said that a lot today.
I say it a lot in my profession, my career.
Um, well, thank you so much, Derek, from Collection House, for such an informative presentation. And thank you to everyone who sent through those questions today. There'll be a copy of the video on YouTube, and a copy of the presentation will go on the members portal and be emailed to registered attendees. So our next event for LGFP is our annual conference and masterclass in Cairns next month. So that's the 22nd to the 25th of November. There are still some spots available, so hop on the website and have a look if you're interested. And Collection House have been associated for a long time with our conference, so you'll see them there. So then the webinar series will restart in 2023. So if there's a topic you'd like to see or recommend, just reach out and let us know. So thank you again, Derek, for such an informative presentation, and we'll see you next year in the webinar series.
Thanks, Zoe. Thanks, everyone.